All righty. Okay, we have everyone with us today. Mr. Barr, my understanding is you are here on behalf of the appellant, and so I would ask you if you wish to reserve any time for rebuttal.
Judge, I'm going to go outside the box today, and I'm going to request 6 minutes.
Well, we have a local rule of 5, so I think it's
Okay,
built
5 is
into
fine.
our charter somewhere, although if you ask me to go find it right now, I have to tell you I'm going by memory and not by actually having looked at the document anytime soon.
5 minutes is fine, Judge.
Okay, thank you, sir. And with that, we are ready to go. Mr. Barr, you may proceed.
Thank you, Judge. Good morning. May it please the court. My name is Chad Barr, and I represent the appellant in this case, Air Quality Assessors of Florida. And for everyone's convenience this morning, I'm just going to refer to my client as Air Quality. We're here today asking the court to reverse the trial court's final order dismissing Air Quality's complaint with prejudice in this case. We've raised 2 issues in our briefs. The first issue is whether the trial court erred in resolving disputed issues of fact at the motion to dismiss stage, principally whether Air Quality's services fit within the definition of an assignment agreement found within 627.7152. And even if this court disagrees with us on the first issue, the second issue that we have to address is whether the trial court erred when it retroactively applied section 627.7152 to a policy that was issued before that statute's enactment. The first,
Mr. Barr, Mr. Barr, that there's nothing in the assignment that abrogates the insured's right to assign upon loss. Is that correct?
I didn't understand the question. I apologize.
The insured had a right to assign upon loss, correct?
The insured did have a right to assign upon loss, yes.
And tell me why the statute does nothing more than set forth a procedure as to how one is going to exercise a vested right.
Well, I think that would go towards the question of whether or not the statute is a procedural statute or a substantive statute. And there's been no argument that the statute in this case is procedural. I think that the common theme is that the statute is substantive. It affects many different rights beyond just whether or not one can assign their rights on a post-loss claim. So it affects.
Well, it really affects the S&E, who has to go through a whole lot of hoops to get
it
the
absolutely
assignment.
does. It absolutely does affect the assignee, which, according to Florida law, stands in the shoes of the assignor. So it's.
But the assignee has no vested rights to anything until the assignment is made by the assignor.
Correct.
Okay.
Correct. But the right to assign the post-loss benefits vest as soon as the claim occurred. And in this case, the claim occurred prior to the date of the enactment of the statute.
Oh, I don't argue with that. I'm just a little unsettled as to whether I should view the statute as substantive or procedural.
Well, and the argument has not been raised in the answer brief that the statute is procedural. The only argument is that the answer brief makes is that we should be looking at the date of the assignment, not the date of the policy. And your honors, there's not a single case. I've read the answer brief over and over and over again. We just had this argument yesterday at the 5th District Court of Appeal, this exact argument. No case was presented whatsoever that demonstrates that this court, the trial court, or any court should be looking at the date the assignment was entered into when we're dealing with a statute that deals with that surrounds an insurance policy. If you look at 6277152, it mentions the insurance policy 21 times. It says 21 times that this relates to the insurance policy. And so when we look at for instance, the 5th District's decision in FIGA versus Johnson, that statute was an anti-stacking statute, but it said in the statute that this statute applies to automobile accidents that occur after the date of the statute's enactment. The insurance company in that case asked the court to look at that statute as it relates to the date of automobile accidents. And the 5th District declined that invitation and said, no, when a statute surrounds an insurance policy or affects an insurance policy, we have to look at the date of the insurance policy's issuance, not the date of the accident.
But the issue of stacking strikes me as more akin to a substantive right that might be covered by the policy.
The same as here, Judge. We have an issue. We have a assignable claim that occurred before the statute was enacted. The right to assign that vested. There was no mechanism whatsoever that limit the ability or the requirements of the assignee in the insurance policy. And now we've got the statute which substantively affects the duties or requirements, obligations, attorney's fees. Everything's affected with respect to 627-7152. Those things are all now in place, and they were not in place when the policy was issued. So the assignee did not have to do all of these things in order to recover payment for insurance benefits. And the same issue was addressed by the Supreme Court in the Menendez case.
But that's a situation. You mentioned assignee. The assignee is a stranger to the insurance contract. And when the assignee comes into the picture to do remedial work, seems to me that the insurer, the assignee walks into a situation at that time.
Well, Judge,
can't rely on the terms of an agreement to which it is a stranger.
Judge, I would absolutely disagree with that, and primarily because Florida law is very clear that the assignee stands in the shoes of the assignor and bears all the duties and responsibilities that the assignor has under the insurance policy. So in this case, we're dealing with a situation where they are a stranger to the contract before the assignment is entered. Once the assignment is entered or signed, they now stand in the shoes of the assignor. And so they're no longer a stranger to the contract. And so what we're dealing with is a situation here where we've got a statute that says in 21 different places that it relates to an insurance policy. It relates to insurance claims. It relates to insurance benefits. It relates to attorney's fees that are recoverable upon prevailing on a claim for insurance benefits. But we're now having a discussion about whether it's procedural or substantive. That issue wasn't raised below, and it just doesn't pass the standards that are set forth in the Menendez case. And so we have to look at this. And quite frankly, there's not a single case. Mr. Strauss is not going to be able to cite a single case with even remotely close circumstances to this, where the court said we should look at the date of the assignment being entered into. And this would be the first if this court were to find that. Instead, the cases where we're talking about pre-suit notice under the PIP statute, where the assignee has to submit pre-suit notice in order to be paid for PIP benefits, that's similar to this, where we have pre-suit notice requirements. And so we're dealing with very, very substantive rights under an insurance policy. We're not dealing with simple procedural issues, and there's simply no case that can support the arguments. Actually, I wouldn't even call them arguments because American Integrity did not raise them. And so we're dealing with a situation where we have to look at the date the insurance policy was issued. There's no clear intent whatsoever in 7152 for the court to retroactively apply the statute to an insurance policy issued before that's the issuance of the policy. And even if there was, that doesn't pass the constitutional test set forth in Menendez. And I think what's important is what the court found important in Menendez. And the reason why the court found that the statute didn't pass the constitutional test in Menendez: it imposed penalties, it implicated attorney's fees, it granted the insurer additional time to pay benefits, and it delayed the insured's right to institute a cause of action. The assignee in this case is the insured for all intents and purposes based on a legal assignment of benefits. So the Menendez case absolutely applies, and where this case went sideways was when the trial court said Menendez doesn't apply. There's no case that supports that finding at all. And then we have, and then I don't want to cut you off, Judge Lewis, if you had any other questions about that. I do just want to briefly touch on the first issue, which concerns whether or not the court should have even considered the motion to dismiss at all, because there was unresolved factual issues concerning whether the services provided, which it was argued at the hearing that it was an engineering report was provided, whether or not that fits within the definition of an assignment agreement found within 627-7152. And the statute itself has to be interpreted based on its plain language. And there's nothing in the statute that says that inspection or assessment services fit within the definition of an assignment agreement.
What
Yesterday,
is the insured going to do with your services? I'm assuming that the insured retains your client's services to help remediate the loss.
it is possible that the insured could use our inspection report to give to another contractor. Our client does not swing a hammer, our client does not put up walls, our client does not take out baseboards. They provide a report.
The reason an insured retains your client's services, correct me if I'm wrong, I'm assuming is part of a process to take care of the loss. I mean, whether or not your client does that or not, the fact is that's the use of the report.
It is possible that report could be used for that purpose. The problem is, in this case, we don't know what the report says. We don't know what the report was used for, and we don't have an insurance policy in the record that indicates whether or not my client's services are even covered. And so
you have a document with the insurer that perhaps is ambiguous. That says we're not going to do any remediation work, but what we do for you is going to be for purposes of dealing with the loss. I mean, that's paraphrasing, but isn't that correct?
It says that and there's no dispute that it can be used for that purpose, but it is not a report to remediate, to protect, to restore, to replace property. So that's where we get into the issue of the factual dispute. And I don't know if your honors saw it, but yesterday I filed a supplemental authority, and only because I just found it. But there's a Senate bill that was introduced this session, Senate Bill 468. And what that Senate bill does is it actually amends the definition of an assignment agreement. And it states that it now includes inspection services. So we can't take the proposed amendment as a clarification. It doesn't state that it's a clarification. It states that it's a proposed substantive amendment, which would address.
We can't do much with it if it's just pending in the legislature.
I agree, but I think it at least provides some support for the argument that there are services with respect to a homeowner's claim that the legislature did not intend when 6277152 was drafted to fit within the definition of an assignment agreement. If that were the case, the legislature could have easily said any service with respect to a homeowner's claim or any services submitted for reimbursement under a homeowner's claim must comply with this provision. It didn't, though. It did not. It said that only the services that protect, restore, repair, replace, or mitigate. And our position is that our services are not for that purpose. And if the court is going to engage in an inquiry regarding whether or not it is or not, then that's appropriate for a motion for summary judgment, not a motion to dismiss. We should be entitled to the full access to the courts to be able to make our arguments, present our case, present our evidence, and not have the court boot us out on some illegal argument without respect to what's in the report, what the report was used for, or anything like that, or what does the insurance policy even cover? A big concern, I don't know if I can call it a concern, but a big question the fifth DCA had yesterday was, how can we analyze this issue without even having the insurance policy in the record to see what is payable under the insurance policy? So there's a lot of unanswered questions, and I appreciate your questions, Judge LaRose, and I think that it all goes to the underlying issue, which is this inquiry, is this line of questioning appropriate for a motion to dismiss? And we would argue that it's not, that it should be presented in a motion for summary judgment. I don't know where I'm at with time, Judge Casanueva. I'm sorry, you're muted, Judge.
I wasn't planning on interrupting. 13 and a half.
Okay. And I just want to just reiterate that we really need to consider this issue of the Menendez two-part test. Even if Judge LaRose, you disagree that this service is in fact within the definition of an assignment agreement, we then have to go to the Menendez test. There's been no argument that this is a procedural.
Don't take my questions as a.
I certainly don't.
My position. I'm just probing.
I certainly don't, Judge, but I'm just saying if it is, we still have to do the Menendez analysis. So I'll reserve the rest of my time for rebuttal, and I appreciate your time, Your Honors.
Mrs. Strauss, you may proceed.
Thank you, Your Honor. And may it please the court. My name is Matthew Strauss with the law firm of Kelly Cronenberg, and we represent the appellee in this matter, American Integrity Insurance Company of Florida. In short, we ask this court affirm Judge Burns' decision at the trial level in regards to his ruling as it relates to standing. And that's really what this case was about. We had filed our motion to dismiss in response to plaintiff's complaints because the assignment of benefits agreement attached to the complaint, which is ultimately the appellant's ticket to the courthouse, was invalid and unenforceable pursuant to the plain language of Florida Statute 627-7152. We, in response to that motion to dismiss, plaintiffs did file a response, it was set for hearing, and the court ultimately adopted our motion in that, one, as Mr. Barr has pointed out, that the services or the assignment agreement isn't an assignment agreement that's attached to the complaint, is an assignment agreement as defined by 627-7152. And two,
Mr. Strauss, how could the court have done that without the benefit of the engineering report? Because the assignment actually, whether you want to call it cleverly or whatever, writes itself out of the statute.
Well, I think ultimately what the court did is took a look at the assignment, the language of the statute, what the definition of the assignment agreement is, specifically any transfer or assignment or an acquirement of post-loss benefits in any manner, in whole or in part, relating to services to protect, restore, repair, replace property or to mitigate damages, along with the statements that were made in its pleadings, specifically that the appellant admitted that their services are in furtherance or used in furtherance of repairs or replacements at the property. That was in their response. That, in conjunction with the language that's set forth in the assignment agreement, that ultimately their services may include destructive and or non-destructive testing.
So you're saying irrespective of the engineering report, that the court could, based on what the facts that you're saying, the court could have made that determination?
Yeah, the issue was standing. The court did not need to look at the policy. The court did not need to look at the actual engineer report or whatever report that appellants relied on. If you take a look at the complaint, they're just alleging that they performed reasonable and necessary assessment services, right? The court
Mr. Strauss, excuse me. I would agree with you that probably what your opponent's client does is done in furtherance of addressing the loss, but the language in the statute speaks about to protect, to remediate, to repair, and could one make the argument that language requires the active participation in protect, remediate, repair, which
I don't think
air quality does not do.
Well, I don't think that ultimately was the intent of the statute, right? The statute and the bill analysis was attached to the record, goes through the AOB, or at least the legislature's attempt to curb AOB abuse while protecting the rights of the insured. Ultimately, the statute was a consumer protection statute, and it's set forth in Section 2, deals with the requirements that must be contained. So the insured is put on notice of the rights or what language must be included within the assignment agreement as it relates to an estimate being contained, when they can cancel, whether they're going to be held harmless or indemnified. Right.
Well, I understand that, but it doesn't answer my question. My question was, when I read the statute, it seems to indicate that somebody must be actively involved in an act of repair or remediation, not providing a report that might be used by such a person.
I would have to disagree with that point, Your Honor. The statute does include, and we pointed out at the lower level, the statute does include a subsection, namely subsection 11, that states what type of assignment agreements are not subject to the statute. and the services that plaintiff, allegedly provides is not contained within that list, right? So I think what Judge Burns did was took a look at the assignment, the definition of assignment agreement, along with the statements contained within the assignment agreement itself, in conjunction with basically plaintiff or appellant's admission that, hey, yeah, these services are used in furtherance of repairs and replacement, right? To say, well, as noted in our brief, that in terms of the duct test, well, this is an assignment agreement, right? I'm aware of at least one decision in the 11th Circuit, which draws an exception to the four corners rule at the motion to dismiss, and ultimately stands for the proposition that ultimately at a certain point in a legal proceeding, common sense applies, right? So I think ultimately what Judge Burns did was it says, okay, they're providing services in furtherance of to protect, repair, restore, replace property, or to mitigate against damages. I don't think there's any issues of fact. This, as a matter of law, the statute, the assignment agreement falls within the purview of the statute.
Well, Mr. Strauss, some of the magic words in the statute is from a person providing services to repair, providing services to protect. Sounds like a very active, direct involvement in providing services that directly impact the house or the property, not necessarily on the face of that document, something that says, give me a bid or give me an estimate of what I might have to do. It looks like it's more direct involvement than an indirect involvement.
Well, I think I understand your line of reasoning. I think in terms of the statute where it says in any manner, in whole or in part, there certainly is an argument that these types of services fall within the definition of the assignment agreement. Obviously, I don't think Mr. Barr will argue otherwise. The language that was inserted into the assignment agreement was inserted intentionally to circumvent the statute, right? I think what Judge Burns did was took a look at the statements that were made at the hearing, took a look at the assignment agreement as a whole, right, where the exhibits control when there's contradictions between the exhibits and the pleadings themselves, and said, this is an assignment agreement, right? That's my ultimate determination, right? And it clearly doesn't comply with the statute, specifically Section 2. There's no argument in that regard. And then ultimately went on to the Menendez argument and found major differences between the Menendez case and the case at Barr, and rejected that argument as well.
Mr. Strauss, Mr. Barr makes a point that sort of intrigues me. I have a contract of insurance, and upon loss, the insured has a vested right to assign. Is that correct?
Correct.
So I guess my question would be, why would I not use whatever statute, if any, existed at the time that right vests?
Well, because ultimately
to assign to a third party.
Ultimately, this lawsuit is not filed by Mr. and Mrs. Mucciaccio. This lawsuit and the query at the lower level was whether the actual statute 627-7152 affected any vested rights of AQA, and right, and in terms of the distinguishing between this and Menendez dealt with an existing structure in place regarding the PIP statute. Then there was a policy, and then there was changes to that existing structure. Here, there was no existing structure in place. It's, AQA, they're making the argument, AQA or Air Quality, that ultimately they had a vested right to obtain an assignment from insureds without including those language requirements, because ultimately the main focus of the query below was not the statute as a whole, but specifically Section 2. Did these language requirements, and we argued it, and I believe it was on the record in the transcript filed by appellant, that these are merely procedural. And I think the Middle District in the SFR Indian Harbor case kind of hit it on the head, where it says these language requirements, Menendez does not apply to these procedurals. Ultimately, and I'll read verbatim from the ruling, that these requirements impose procedural requirements of AOBs to be valid and enforceable, and it only affects the rights under the AOB. It's not whether benefits can be assigned or how that is, just how that assignment can be accomplished, right? So I think the Menendez, there's major differences between the Menendez case and the case at issue. Most notably here, we have an AOB company bringing suit as opposed to an insured, and ultimately the AOB, the statute that's in effect, was in effect prior to the signature or the execution of the assignment of benefits agreement. So,
Mr. Strauss, I'd like to approach it from a slightly different aspect. This is more procedural, as it deals with the status of the pleadings at the time the trial court ruled, and the absence of an insurance policy in our record. I look at the statute in subparagraph B that defines an assignment agreement. Would not the trial court, in order to make a resolution, need to know whether there is a policy of residential property insurance and that policy provides post-loss benefits that are defined in compliance with the statute? I understand we came in on the pleadings. There was no insurance policy in the record. They alleged they didn't have one. So how does the trial judge make a statutory definition that says this assignment is covered without knowing exactly what the policy says, or whether the policy exists, or whether the policy was in force at the time the assignment was made? And I realize it may not be as interesting an issue, but for me, having, like Judge Smith served as a trial judge, you kind of work in block steps. You look at the statute and it tells you this is the definition. Does our record prove the definition?
Well, in short, to your question, the policy, we didn't contest whether there was a policy in place. We didn't contest whether there, what the
lawyers say at a motion to dismiss is not proof or evidence. It's not even, unless it says we stipulate. So is there a stipulation I could look for?
There was no stipulation in that regard, Your Honor.
Okay, go ahead. That was just go ahead. I didn't mean to interrupt you.
Yeah, but there was no, nothing raised in terms of whether there was a policy in effect, whether the insureds had paid premiums, whether the insureds had a bare bones premium that did not that prohibited assignments, or whether there were post-loss obligations, right? The query and the question for the court was whether, again, this assignment agreement complied with the statute, and whether, and then when it ultimately determined it did not, whether it had to or not. And based on both grounds, namely the definition of assignment agreement and the Menendez argument, the court found that it did need to comply with the new statute, right? Again, just to get back to the Menendez argument.
Mr. Strauss, could I go back to the point that Judge Casanova was making? For purposes of the motion, there's nothing in the record where your client challenged the fact that there was a covered loss. Well,
we didn't get there, Your Honor. They had filed, okay. We didn't even get there. We didn't get to anything in terms of the only thing that was touched on in our responsive motion was the standing issue. And that was the query for the court of whether they had a valid, basically, ticket into the courthouse based on their assignment to actually move forward with the case and get to the merits of the breach, and whether the carrier breached or not. And we didn't. And again, we didn't get there because the standing was the first prong of our defense, and ultimately the court determined that appellant did not have standing based on the failure to comply with the statute, or the assignment being invalid, and the inapplicability of the Menendez case, right?
And Mr. Strauss, the court, you presented the court with a document that was beyond the four corners of the complaint, correct? That the court reviewed.
In which document, Your Honor?
The engineering report, that was not included in the pleadings, correct?
That was not included in the pleadings, and that was not part of the record. The court, we made the argument, Your Honor, we don't need the report, we don't need the policy. the focus of our motion is strictly limited to standing. It's strictly limited to, the assignment of benefits agreement attached to the complaint in conjunction with the clear language of the statute, along with plaintiff's, response where they, conceded, yes, we do provide services in furtherance of repairs and replacement, right?
Okay, and if we find that that concession didn't happen, does your argument fail?
Not necessarily, because again, there is language contained within the assignment agreement. If they had not filed their motion in response that made that concession, and they focused solely on what's attached to the complaint. Again, the assignment agreement itself states that they provide, provide services, destructive and or non-destructive testing to determine the repairability scope of the damages. I think that
to determine the repairability of the damages.
Correct. Okay. So that in conjunction with.
But to determine is different than to protect, repair, and restore. That's,
I'll respectfully disagree in that regard. The statute contains an exclusionary subsection where appellant's services are not listed there within. The judge is only allowed to evaluate what's being conveyed, what's in the record. I do not believe he looked outside the four corners. He looked at the complaint, looked at our response, looked at the statute, and he looked at plaintiff's response and ultimately said, wait, this is an assignment agreement. You do not comply. Therefore, the assignment agreement is invalid and unenforceable based on the plain language of the statute, right? And the Menendez argument was shut down as well because of the major differences between Menendez and the case at issue, namely the AOB company, AQA. They had no vested right at the time that the statute was put in place on July 1st, 2019. They had no vested right in the policy, and there was no arguable vested right under Florida law that said, we would change what the structure that was put in place did, right? There was no law similar to Menendez where, again, there was a law in place that was ultimately revised. That did not occur here, right? And even further, as a last point, the query to the court was solely of the interpretation of Section 2, which in our argument, which we raised, these are procedural requirements. That the language requirements are to protect the insured. They do not affect any vested right of the insureds. They're to protect the insured, and they're not. The Menendez application does not come into play. And there are cases, again, that distinguish Menendez, where ultimately procedural requirements or remedial measures are put in place that do not deal with substantive rights. So when the court took a look at the statute, focused on Section 1, namely the definition section, within Section 2, which again, clearly appellant's assignment of benefits was not in compliance with, saw that there was exceptions in Section 11, and Section 13 lays out what the effective date is, and looked at and some and said, okay, this is an assignment agreement. I'm gonna, it's invalid and unenforceable based on the plain language of the statute, and ultimately did not agree with the Menendez argument, right? I think one thing that I want to point out, because I know appellant pointed to or cited numerous cases in his, both his initial brief and the response brief. Many, if not all of those cases deal with assignment of benefits, right, that are dated prior to July 1st, 2019. In addition, many, if not all of those cases deal with the issue of attorney's fees, which again is not an issue in this case. What's submitted to the court, the most persuasive, again, there's no binding authority, but the most persuasive case is the one that we submitted, the SFR Indian Harbor case, which dealt with a post-July 1st, 2019 AOB, and really touched on the Section 2 of the statute and whether those language requirements were substantive or procedural, and the court ultimately ruled in the latter.
Mr. Strauss, before your time totally expires, a comment that you made caused me to think of something. You mentioned, and I think Judge Smith asked about it, that they were looking to determine the repairability of the property. I would go back to that point and link it to this. It was my experience, particularly after Hurricane Charlie, that a reading of policies that then existed to cover for loss for residences had a cap in it, and that the insurance company had an electoral right to say the cost of repairing this house exceeds the value for which we are going to insure you. So we're going to hand you the maximum payment of your policy. You go get it repaired. So I'm wondering how you can determine that, again, without the insurance policy being in this record, combined with the language, I guess. Well, forget that. We asked that question about the tense of the verb, but I'm concerned that this may have nothing to do with repairing. It may be saying, I may have an insurance problem here that I'm going to have to discuss with my carrier whether or not they're going to repair my house or not.
Well, again,
how do you do that without knowing what the policy says?
I'm a little confused by the question, Your Honor.
Okay, if you have an insurance policy, it tells you what your benefits are and maximizes the amount that the insurance company will have to pay based on certain valuations of the house. Subparagraph B says that you have an assignment agreement, post-loss benefits under a residential property insurance. If you don't have that policy in the record, how do we know that this goes to actual repair or just an assessment about whether or not it is repairable? And then we would actually go down to about the next language about, person providing services. But I'm concerned, again, about the operation of the analysis without the insurance contract being in the record. And because I remember quite clearly at the time of Charlie, which went through a different part of Southwest Florida, people were finding out that the value that they insured their house for, whether it was tax purposes or not, inflation had driven it up, and then the cost to repair for some insurance policies, it was better for the insurance company to elect to say, here's your check, you go repair it, not us.
No, I understand.
I'm talking about the need of the insurance policy to ascertain certain things.
Understood. And again, we could have filed the insurance policy, or we could have, moved for a more definite statement.
And you probably could under a motion for judgment on the pleadings. This was a motion to dismiss. That's my concern.
Well,
the procedural posture.
I understood, but there was no issue in terms of what the policy said.
Well, we don't know that because you're the movant and you have to carry the burden of persuasion to show that this defense operates under this statute, and this statute has a definition of what an assignment agreement is that is premised on a residential property insurance policy, which is not in our record.
Understood. And appellant did not.
And if this may pass by like ships, it may not matter, but right now I need your response because it's going to help me analyze this.
No, and appellant did not, ask the court to stay the proceedings or request that the hearing be postponed until it had receipt of the policy. We don't even know if they did have receipt and they just did not attach it to the complaint. But it was our position that we didn't need the policy. Again, we didn't need the policy. We did not need the engineer report to invalidate the assignment agreement and attack the standing. And that was really the sole issue for the court. Is there standing?
So if I summarize it correctly, it would be, I don't need the policy because we're only on the limited issue of standing.
Correct, Your Honor.
Got it.
I hope that helps. And thank you for clarifying.
No, thank you for working with me. I appreciate it very much so. Because like you've all said, there's not a whole lot on this matter. And I want to make sure that, that we're not, we illuminate as much light as we can. Okay, we've taken you way beyond 20. And so, okay. I thank you. I'll stop the clock here, clear the record. And counsel, you have your 5 minutes of rebuttal time.
Thank you, Judge. Appellant's argument, each of his arguments stopped just one step from where the law actually is on these points. And where I want to start out is to your point, Judge Casanova, and your point, Judge Smith. The statute's very specific about what services beyond just the definition of an assignment agreement, because it tells the assignee what it needs to do. But what it's also doing is explaining to the court, explaining to us, explaining to the policyholders exactly what services are being governed by this statute. For instance, in section 2A4 of the statute, it requires the assignment agreement to contain a written, itemized per cost unit of the services to be performed. In provision 4D, it requires, as a condition precedent to file suit, the assignee has to submit to examinations under oath based on the scope of the work. In section 9A, as a condition preceding to filing suit, the assignee must provide a detailed written invoice of the estimate of services, including itemized information on equipment, materials, and supplies, and the number of labor hours. This goes, Judge Smith, you hit the nail on the head, proverbial pun absolutely intended, but you hit the nail on the head here. This goes to, if anything, it goes to whether or not the loss is covered or repairability of the damage. We can't decide any of these issues by just looking at the assignment agreement. We can't decide any of these issues without some evidence in the record. We can't consider any of these issues. If we just have an assignment agreement, or sorry, we just have an engineering report that talks about repairability, but no work was done, is that services to repair, restore, replace, or remediate? No, it's still an assessment. It's an inspection. It's designed strictly to provide assistance if it is needed in determining the repairability of the property. The other thing I want to point out is Mr. Strauss kept saying, well, this is just about one provision of the statute. Well, I haven't heard any argument. I haven't heard any case law that says that this court can take this statute and piecemeal it and figure out whether it can be applied retroactively in piecemeal or not. If you look at each of the only courts really beyond trial courts that have really analyzed this issue have been the district court, the federal district courts. And I've provided in my initial brief and my reply brief decisions from the middle district and the southern district regarding this issue, this exact issue. And yes, those cases talked about attorney's fees, but you know what? Because it's in the context of 7152, that is an assignee's right to attorney's fees, not the insured's right to attorney's fees. So if it's affecting the assignee's right to something that is available pursuant to an insurance policy, then the statute is a retroactive application. So the federal courts got it right. And just recently, and I just found this case this morning, but there's a new statute that was enacted that affects now insureds, 627.701 or 70152. And the southern district just ruled that statute can't be applied retroactively either, because it includes all these obligations and duties. So
I thought, Mr. Barr, excuse me, I thought Judge Badalamenti, one of our former colleagues now in the middle district, I thought he came out with a decision that said the date of the assignment is what is key and not necessarily the date of the insurance policy.
It is possible if that's the case that the appellant cited to in their brief. I think the reality is that sometimes people get it wrong, and I think that decision is wrong. And we're looking at this issue. The Supreme Court of Florida has held that the right to attorney's fees is a substantive right. So there's nothing that we've been presented, nothing that's been argued in the briefs that says that this statute can be piecemealed and taken bits and pieces and decide which part of this are we going to retroactively apply, which part of this are we going to prospectively apply. None of that. It's either all or nothing, and that's what we're dealing with in this particular case. The other issue is again the insurance policy. Judge, your questions about the insurance policy are valid. These were the exact same questions that the 5th District had yesterday about the insurance policy. What is covered? Is there coverage? There's nothing in the record to demonstrate what the policy covers, if there is coverage, or perhaps even whether or not this engineering report went to the issue of whether or not the loss was covered. So we're dealing with an IRMA loss with a hurricane deductible We don't know what's covered. We don't know what is repairable. We don't know anything about the insurance policy. So we've got a ton of issues that we have to work through and deal with. A lot of these are going to involve discovery. And I think that the court should have resolved this issue later on, and it should have reserved to resolve this issue in a motion for summary judgment, not in a motion to dismiss.
I need to advise you that it will probably take more time to resolve those, but yours expired on this oral argument a little bit ago. So I wanted to see if we were going to get to an end of a paragraph or a sentence, but I need to say that we have concluded.
I am finished, Judge. Thank you.
I thank you. I thank you both for all your efforts to respond to our questions. It's very appreciated by us. And please, for all of you, stay well. We hope to see